Assalamu alaikum and a very good evening to Madam Shikin and my fellow friends. We are from Group 17 and we will be presenting on the topic of judicial interpretation. In this presentation, we will be focusing on the prismatic approach used in the judicial interpretation regarding the provision of the Constitution which affect the fundamental liberties. This presentation will be divided into 6 parts. The first part is the introduction, where we're going to explain on the role of judiciary. In the second part, we will discuss briefly on the fundamental liberty in the Constitution. Thirdly, what are the methodology used in our project? The fourth part, we're going to explain all about the prismatic approach. The fifth part, we're going to discuss on the issue of the prismatic approach for balancing between the rights of accused and actions combating terrorism. And lastly, we're going to make conclusion. Without further ado, I will pass this presentation to the first presenter.
Assalamualaikum and hi, my name is FARHAH NAJIHA binti Muhammad FAIRUZ and my metric number is 054997. Today we'll start our presentation with our introduction. So what is the role of the judiciary? The most important role of the judiciary is to protect the supremacy of the Constitution. The judiciary also has to make sure everyone abide by the federal Constitution, and the judiciary has been given power to interpret words written in the Constitution, and lastly, the judiciary have to decide whether any laws passed by the parliament or any act of executive is constitutional and valid. So, as the judges have the duty to protect and defend our federal constitution, in Article 4 Clause 1, which talks about supreme law of the federation, Article 128, which talks about jurisdictions of the federal court, and Article 162 Clause 6, which talks about existing laws. Based on these articles, it provides the power of the court to review the constitutionality of legislative and executive actions by referring to constitutional norms. So basically, judges always find ways to add moral colors during the interpretations of laws in which that laws leads to unjust results of issues raised by the public policy or public interest. As Justice Holmes once said, a word is not a crystal, transparent and unchanged. It is the skin of a living thought and may vary greatly in color and content according to the circumstances and the time in which it is used. It is for the judge to give meaning to what the legislature has said.
Hi, my name is NORASYIKIN binti SALIM and I will continue on the fundamental liberty and also the methodology. Fundamental liberty are rights and freedom as a human being. The Federal Constitution of Malaysia has guaranteed the fundamental liberties and it is stated under Article 5 to 13 of our Federal Constitution. Each article has different fundamental liberties such as liberty of the person, prohibition of slavery and forced labor, protection against retrospective criminal laws and repeated trials, equality, prohibition of banishment and freedom of movement, freedom of speech, assembly and association, freedom of religions, rights in respect of education and also rights to property. However, these liberties and rights are not absolute and it is subjected to limitation and exceptions. For example, we can see under Article 10 which regards to the freedom of speech. It stated that every citizen has the right to freedom of speech and expression. However, there is a limitation and exception to that freedom, where Parliament may make laws to restrict this right if they are necessary or expedient in the interest of. Alright, so next we move on to the methodology. So here, methodology is a system or method which used in particular study or activity. It is a library-based study for the purpose to ascertain opinions, attitudes, factors, likes or dislikes, which will be explained through the three major items, which are sources of data collection, collection techniques, and also the data analysis technique. Okay, so we will go to one by one of the three major items. Okay, the first one is the sources of data collection. Here, the sources of the study will comprise both primary and secondary sources. This legal research will involve sources from statutes and legislation. Besides, this study also uses secondary sources which are law journals and articles. Alright, so the second major item is the collection techniques. The strategies used to collect data for this study are through journals and an online database where most of the material of this legal research may be available. Next is the data analysis technique. The data analysis technique that will be used in this study is content analysis, where all the collected data will be analyzed and inferred. The findings of the study will be made based on inference of the researchers to come up with the factors, effect, and its relevant solution.
My name is Siti NURAIN binti MAHADI, and I will continue the presentation. What is meant by prismatic approach? Prismatic approach is illustrated as when a ray of light passes through a prism, it is broken down to show some color components. In other words, it can be seen when judges try to use this kind of approach to convey on how they interpreted the provisions in the Constitution. All of the Constitution of Commonwealth has agreed to the role of the judges to not interpret all the provisions narrowly but in a broad manner. In the case of Lee Kuan Yew against public prosecutor, the judgment was written by Federal Justice Gopal Sriram. It is duty of a court to adopt a prismatic approach when interpreting the fundamental rights guaranteed under Part 2 of the Constitution. When light passes through a prism, it reveals its constituent colors. In the same way, the prismatic interpretative approach will reveal to the court the rights submerged in the concepts employed by the several provisions under Part 2 of the Federal Constitution. Indeed, the prismatic interpretation of the Constitution gives life to abstract concepts such as life and personal liberty in Article 5, Clause 1 of Federal Constitution. For example of prismatic approach used in a case, for instance, it can be seen in the case of where freedom of speech, the right to privacy or other cases under Part 2 of Federal Constitution. In the case of Tan Teck Seng against Suruhanjaya Perkhidmatan Pendidikan, it illustrates the definition of life that consists all of the aspects that are an important part of life itself and the things that shape the quality of life. Thus, every fundamental freedom places has many other rights stated in it, even though the other rights are not clearly stated, but it still exists under the provisions. Next, in the case of Nik Nur Hafizi bin Ibrahim, Hamid Sultan Judge interpreted that Article 10 of the Constitution did not permit to criminalize an assembly which was not licensed. Furthermore, the right to assemble peacefully is a guaranteed right that stated clearly in the Constitution, and there could not be penal sanction legislated when citizens assemble peacefully without committing offences under the Penal Code. It is used to allow the terms of right to having an assembly but denied if assembled while committing an offence under the Penal Code. It gives protection to the rights of assembly to the person. Therefore, the court task of interpreting this concept is to find out whether certain rights that are claimed to be violated by state action are indeed rights embedded in certain concepts or vice versa. Justice Kirby eloquently reminded us that broad manner of interpretation enable all people in the country to the fullest enjoyment of their rights under law, but it must be interpreted carefully to not put the entire constitutional at risk. That's all from me.
Assalamualaikum and hi. My name is HAZIRAH binti RENOOR. My metric number is 056801. Now, I will proceed with the explanation of prismatic approach. In the past, the application of literal and positivist approach to the Constitution were used by our courts, which the adoption of the same principle of constructions for the interpretation of ordinary acts of Parliament. However, this outdated approach have been firmly opposed by the common law and our courts, as it is tried that the Constitution should be viewed in a prismatic fashion. The Constitution is said to be a living piece of legislation and must therefore be broadly construed with less rigidity and more generosity, not in a pedantic way. When interpreting fundamental liberties, it is the duty of a court to adopt a prismatic approach rather dogmatic approach, because the court can interpret the rights submerged in the provision under Part 2. The function of interpreting a written constitution is very important to the country's governmental process. Thus, the judicial approach to this task has to be completely different from interpreting a statute. Interpreting the constitution and declaring a parliamentary statute that unconstitutional may affect the whole governmental process, legislative process in the country, and policy making. The Constitution is the basis of the entire system of government. The fundamental liberties of the people is guaranteed by the Constitution, as it distributes powers between the various organs of the state, which are the executive, the judiciary, and the legislature. Under the federal constitution, there is a delegation of powers between the federal government and the states. Therefore, interpretation of a constitution is different from interpreting a statute. Such method of interpretation is well illustrated in the case of Minister of Home Affairs against Fisher. In this case, the Privy Council emphasized that the relevant approach to constitutional interpretation for constitutions based on the Westminster model called for a generous interpretation to give the individuals the full measure of fundamental rights and freedoms. In the case of Pihak Berkuasa Negeri Sabah against Suguma Balakrishnan, the Federal Court disagreed with the Court of Appeal that the words personal liberty in Article 5 Clause 1 of the Federal Constitution should be generously interpreted to include all those facets that are an integral part of life itself and those matters which go to form the quality of life.
I'm Asma Izzati binti AZIZUDDIN, and I'm going to discuss on the issue of prismatic approach, a very necessary tool for balancing between the rights of accused and actions combating terrorism. Article 149 of the Federal Constitution enables Parliament to make laws against a range of threats to the Federation and being consistent with the fundamental liberties provided in Part 2 of the Federal Constitution. They are the right to liberty, Article 5, freedom of movement and freedom from banishment, Article 9, freedoms of speech, assembly and association, Article 10, and right to property, Article 13. The new rules established in Malaysia to combat terrorism and related offences such as Security Offences Act 2012, or better known as SOSMA, and Prevention of Terrorism Act 2015, though managed to offer a certain positive outlook and guarantees, but will impose ripple effect on the freedom of the people when enforced blindly. The decision of A against Secretary of State for the Home Department will be used as a point of reference by courts all over the world for decades to come. However, the cases show a reluctance to scrutinize into the acts of the executive when facing preventive detention matters. commonly known as substantive review and strict approach to procedural queries. Further investigation will not be made on the truth of allegations in respect of decision to detain. Instead, the executive authority is the sole judge of what is in the security of the Federation. The case of Karam Singh against Menteri Hal Ehwal Dalam Negeri Malaysia, Salim Chin against Inspector General of Police, and Karbal Singh against Menteri Hal Ehwal Dalam Negeri Malaysia illustrates the position in Malaysia. Under these cases, detentions are considered lawful as long as the detaining authority was personally or subjectively satisfied that it was necessary to prevent a person from acting in a manner prejudicial to Malaysia's security. Security matters are deemed to be the responsibility of the executive, who are thus regarded as the judges in the matter of preventive detentions relating to the security of the Federation. This not only means that security concerns take precedence over the fundamental liberties of the individual, but also that there are no effective legal checks on the executive discretion, which is contrary to the rule of law. Such approach puts significant effect into further curtailments of rights and liberties and unnecessarily reinforce further the wide power of executive. Judges have numerous ways to ensure good governance. The prismatic approach will ensure the rights and freedom of the people are not curtailed relentlessly when actions were taken to combat terrorism. Such approach may reach the scope that authorities' decision must be rational, logical and reasonable. The power exercised should be within reasonable period and for proper purpose. Mr. Justice Danning emphasized that personal freedom must be matched with social security, by which the peace and good order of the community will live. The moral is that a true balance must be kept between personal freedom on the one hand and social security on the other. Restrictions on individual liberty for purely or doctrinary reasons can never be justified, for in a free society, the rule of law should never be primarily to restrict but to protect, and it should restrict only insofar as this is necessary for the protection of those who need it. This clearly means that no one can be allowed to do his own thing at the expense of other individuals or of the community as a whole. For a doctrine of liberty which is purely individualistic belongs to a bygone age. The ultimate goal is people and government are as thick as thieves, alike body and soul. The rights of the people may only jeopardized by correct amount of restrictions, while the government are all accountable and responsible for their actions. The laws will be here to regulate the society, but when the laws touches on the rights of the people, in the interest of public, curtailment of these liberties is permissible but should not and never be made absolute. The judges need to interpret the Constitution by giving life and spirit to the cold printed words of the Federal Constitution. Judges must take any responsibility proactively in the delivery of justice, so as to contribute to the quality of justice. In other words, judicial legislation is vital when fulfilling the task of interpretation, and perhaps these become more precious, especially on the provisions relating to the rights of the people or the fundamental liberties enshrined in the Federal Constitution. That's all for me, and I will pass to my friend for the conclusion.
So, in conclusion, it can be seen that the prismatic approach taken by the judges is deemed to be necessary to interpret the law, such as our federal constitution. This is because it is important for judges to interpret the words written in the Constitution with less rigidity by adding more colours and generosity, especially when interpreting the fundamental liberties to ensure that the citizens' rights are protected. With prismatic approach, the judges will be able to give rational judgments that are both just and equitable.